Ms. Bennett, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for one. You need to understand that this charge is going to go on your record. It's going to be there for the rest of your life. It's going to be there, it's even there after you die.
Welcome back to the docket. We're starting with a heavy reality check. The judge is telling Miss Bennett that a DWI doesn't just go on your record. It stays there even after you're gone. Legal insight. In Texas, a DWI is enhanceable. That means your first mistake is a misdemeanor, but your third could be a third-degree felony. The court is basically saying, the clock never resets. Let's roll, nerds.
This is important because you ever get pulled over again, officers, all they do is they look at your background, and if they see a lengthy background, it's just not going to go well for you. It doesn't matter if you're falling down, piss-ass drunk. No, the mere smell of alcohol or dope, you will probably be looking at another DWI. What we're doing today, from now on, here in Harris County, you are facing, or in Texas, you're facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? No more proverbial slaps on the wrist. So if I were you, whatever you're going to do, don't get into a car because it's a humongous liability that you're in, a risk that you're taking. What Max is asking me to do is to take off around $3,500 worth of fines and fees. The idea is that we all make mistakes, right? But you can't keep making mistakes where you endanger other people's lives.
Boom. The judge just dropped the Uber truth bomb. For $30, you get a ride. For a DWI, you get a $2,000 fine and a permanent record. Reaction. You can feel the judge's frustration here. In the age of rideshare apps, the court has zero patience for excuses. Engagement question. Do you think the availability of Uber should make DWI penalties even harsher? Let us know in the comments.
It's not fair. When it's so easy to hit one damn button on your phone, for $30 to $40, you have a car waiting to take you anywhere you want to go on this. Do you understand?
Yeah, you said.
I want you to understand one more thing. It's unacceptable the way that you have been treating us here in court. You were ordered to get an interlock. You have not had an interlock since August. It's not.
Judge, she did have it installed. There was
if it's in lockout.
I understand, and there's a
it's as
issue with the money and all that, but yes, sir, we understand.
But you don't wait. If
you communicated with me, I didn't realize there was another option, Judge, and so I'm definitely taking the heat on that. So I came in to see if we could.
I'm not going to let you. You are old enough to know that if you're ordered to have an interlock and it's not functioning, you're going to upset a judge. Do you understand?
Wait for it. The financial hardship defense. Miss Bennett claims she hasn't had her court-ordered breathalyzer in her car since August because she couldn't afford it. Sharp take. Here's the legal trap. If you can't afford the interlock, you aren't supposed to be driving. Period. Communicating with your lawyer is great, but until the judge signs a new order, you are technically in violation of your bond.
Judge, I'm gonna have to speak on that one, okay? Yes. Because I definitely communicate. I said I've been employed my whole life. When this stuff started happening, especially with the stuff with the other situation that happened going on, I let him know that I can no longer afford it. I didn't know there was another option.
And I neither. I told her
since August, she's been in lockout, Max.
I have not drove. I Ubered everywhere I've been.
It's true.
I have.
And I helped her with that as well.
Yeah.
She has.
So now I'm responsibility for it, and I just don't want you to think that I just deliberately disobeyed an order. I didn't have a choice, and I communicated it with him. I'm taking full responsibility. So for you to tell me that, oh yeah, I am old enough.
If you see, and the lawyer has been notified, and still nothing is coming of it, you got to come to court. When you have an interlock, it's supposed to be operational, and when it's not, that's a bond violation, and it's a continued one.
I understand.
Look, I'm
taking full responsibility.
I'm preparing you for the future,
Yes.
Hopefully there is none, but you can't keep it.
Also, before all of this and the federal thing, she'd never been in trouble before. So this has been like...
No.
Watch. The first rodeo defense just hit a brick wall. The lawyer says she's never been in trouble, but the judge pulls up receipts from 2009 and 2010. Pro tip. Never tell a judge she's never been in trouble without checking the NCIC report first. The judge has a computer and he knows how to use it. This just turned from a routine plea into a credibility nightmare.
I have an assault from 2010. I've got an ag assault in 2009. I've got a gun case in 24, so it's not our first rodeo. It's not.
Okay.
And just
She's like really upset about
the idea is we all make mistakes, like I told you, but don't make a mistake. I'm sorry. It's not a mistake. They're actions that you take, and you're old enough to know that actions have consequences, right?
This is a masterclass in judicial perspective. The judge isn't looking at a car, he's looking at a 5,000-pound missile. When you add alcohol to that equation, the legal stakes shift from traffic violation to public safety crisis. This is why he's waiving the $3,500 in fees but keeping the jail time. It's about the lesson, not the money.
Especially when you're dealing with alcohol and a 3,000 to 5,000 pound missile that you're in. You could cause catastrophic injury, and that's what we're trying to prevent.
Understood.
All right. I am going to waive the fines and fees now, but you need to understand on a second offense, it's a minimum of $6,000 in surcharges and fines and fees if you pick up another DWI. So when people continue to make actions where they endanger other people's lives, it gets extremely expensive, not to mention costly with jail time. You understand? All right. The agreement you've worked out is 3 days in jail, credit for the 1 day that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, you can never change your mind. You can't say, well, I didn't know this was going to happen. I didn't know this. Once you plead guilty, it stays like this forever. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? I'm going to find you guilty. I will sentence you to it. I'm going to waive your costs, your fines and fees. There is a license suspension that is attached to this. I am going to suspend your license. I'm going to suspend it for...
The hammer drops. 3 days in jail, license suspended for 90 days, and a lifetime of looking over her shoulder. Final summary. Miss Bennett got the fines waived, but she lost her right to drive. The judge's parting words are the most important. Do not drive until you get a license. In Texas, driving while your license is suspended for a DWI is a fast track back to a cell. We're out.
90 days. Do not drive until you get a license. Good luck, man. Thanks, folks. Please see the clip.